Yes, good afternoon, Council.
Good afternoon, my lady.
Good afternoon, Ms. Tucker.
Good afternoon, my lady. I just want to confirm that the court can hear me.
Yes, I hear you very clearly. Thank you.
Thank you.
Yes, so this is the appeal of Shae Buttefield, case number 3 of 2022. Where is Mr. Buttefield?
Yes, my lady, Mr. Buttefield is actually present with me in the room. I'm happy to for him
I can
to.
just have a glimpse of him. That's good
Yep.
enough for me. Thank you. All right, thank you, Mr. Buttefield.
All right, you're welcome, Madam.
Yes, so shall we start?
Yes, my lady.
Mhm.
I am going to start by introducing myself as the counsel representing Mr. Buttefield, Sarah Tucker. My learned friend, Ms. Shae Simons-Fox, represents the Crown for the purposes of appeal. And I would just like to indicate that I am only representing for the purposes of appeal, and I had not been counsel acting, and no counsel acted for the purposes of the original trial.
Yes, he was unrepresented at the trial. Is that correct?
That's correct.
Okay, thank you.
Yes. So, my lady, we appear on an appeal against the findings of the lower court, which we say constitute a miscarriage of justice with respect to Mr. Butterfield's particular case. We are aware ultimately that this is a court which takes a cursory overview of the trial scenario and narrows down on the particular points of law and fact which may need to be addressed for the purposes of an appeal. I have supplied the court and my learned friend with a skeleton argument, which sets out 3 primary grounds of appeal, which has been extracted by counsel as the grounds which give merit to the application which is being presented today. Just by way of background, Mr. Butterfield was convicted of the offense of possession of a controlled drug, cannabis, which was intended for supply on the 21st of December, 2021. And he was also convicted of possession of Delta-9 tetrahydrocannabinol on that same date. I would like to take this court to my first ground, which is contained at page 2. And just as a matter of housekeeping, I have supplied the court with 3 authorities, but I will only be referring to 2 for the purposes of this application, which is the matter of Art Simons and the matter of Boyson and Regina. So firstly, as it relates to the overall ground 1, it is the appellant's position that the worshipful magistrate misdirected himself and or failed to direct himself as to the credibility of the Crown's witnesses. And we say that their credibility is undermined by their inconsistent evidence as the arresting officers at the time when the appellant was seized or apprehended. Just dialing it back and as a backdrop, on the 16th of February, 2019, Mr. Shae Buttefield attended the BAA for a football match, which was a high-profile football match. The high-profile football match ultimately required the attendance of police, and there were police around the grounds, which I do not believe is disputed by the Crown. It is then a part of the Crown's case, at least, that Mr. Butterfield had been standing on, or had been seen standing on, what were controlled drugs, or what turned to be controlled drugs. And it is also a part of the Crown's case that he ran from the scene and was stopped by the Butterfield and Valley's warehouse that's situated outside the entrance gates of the BAA field. And he was arrested with what I believe to be controlled drugs.
He was approached by a police officer directly, and he ran from the officer. He gave chase to the police officers.
Yes, he gave chase to the police officers, yes. We are ultimately not here for the fleeing police, but we are here for the drugs that were said to be in his possession at the time of these events. Now, one of the issues that I've faced as tackling this matter after the fact is the scenarios at play, which are said to have resulted in Mr. Butterfield being in possession of drugs. And when I say that, I say from review of the case, there seems to be two clear points at which drugs are found on or near Mr. Butterfield. There is at the BAA on the field near or around his feet, and then two in a jacket pocket, which
Well, that's the defense case. The defense case is that it was the drugs were seized from the jacket pocket. The Crohn's case, which the magistrate accepted, was that it was pried from his hands and it dropped.
Yes, my lady, I do appreciate the Crown's case, and there are several other instances where
Now, if you're going to summarize the facts and they differ on the Crohn's
Yes.
case as opposed to what the defense case was, we should be
Yes.
clear about that.
Yes, and I appreciate that.
Mm.
So yes, it is the defense's position that there are 2 points in issue with respect to drugs. The first is with respect to the drugs that were found on the field. And the second is with respect to drugs found in the jacket pocket of Mr. Butterfield. It is my understanding from the Crown's case that there were several issues or several scenarios in which drugs may have or may not have been found on Mr. Butterfield. The first is around the feet area of Mr. Butterfield. The second is as a result of Mr. Butterfield casting drugs from his or items from his pocket when he was fleeing the police officers.
So one moment, because the Crown's case, as I understood it, was that as he gave chase, he was discarding objects. It was a
Mhm.
cell phone that was retrieved.
That's
after that
correct.
chase.
That's correct.
Okay, I
So
do
there was a
accept.
clear plastic bag, on the Crown's case, it was a clear plastic bag that he was standing on at the field.
Mhm.
That was what gave rise to the suspicion of the police officers. He didn't move his foot, etc.
Yes,
Gave chase, he discarded some items. Amongst the items that were retrieved was a cell phone. When
Yes.
he was apprehended on the Crown's case, he pried open your client's hands, and that's when these red plastic bags containing the controlled substances were further seized. That's the Crown's case in a summary, and I see the prosecutor giving me a nod of affirmation.
Yes, my lady.
Okay. And since we are on the point, the last part of what I gleaned from the Crown's case is that Mr. Butterfield, not in addition to having drugs in his hand, pried from his hand on the Crown's case, drugs were also seized from the pockets or jacket pocket from Mr. Butterfield. I can be mistaken.
Not on the
but that-
Crown's case. I mean, Miss Simons-Fox can weigh in here, but what I understood was that's where the cases diverged. And your complaint is that the magistrate did not accept what the defendant had to say about that. The defendant said, no, appellant, is that this was his uncle's jacket that he had bought from his uncle the night prior or some recent period
Mhm.
leading up to that event, and that's where they were seized. The Crown's case is that no, they were seized, they were pried from his hands and they dropped, and that's what was taken. Nothing was seized from the inside of his jacket.
If I can be of assistance, my lady, what was seized from pockets were currency, not
Thank you, cash, the cash.
Yes.
that's right.
Okay. Okay, well, I am grateful for the clarification. So in this scenario, then we have the defense's case, and what the defense's first line of argument is on the appeal
Mhm.
is that the magistrate erred in considering the witnesses presented by the Crown with respect to the 2 officers arresting the appellant as credible. And I turn to the evidence of Officer Reagan and Officer McHugh to substantiate that finding or that submission. Now, we say it's imperative that the court does take into account the credibility of the witnesses, which are the police witnesses, because what we have here is a defense that the appellant is suggesting is based around knowledge and the circumstances which may or may not have given rise to any particular point of knowledge. And for us, our first position is that the Crown have argued that there may have been drugs on or near the appellant's feet. That is the first interaction with the officers, Mr. Reagan and Mr. McHugh, which were presented by the Crown. The officers differ in what they say had been found near or around the appellant's feet upon first instance. And I have had sight of my learned friend's skeleton argument, and I will make reference to it, but at first I want to just take the court to what we say is the material difference between Officer Reagan and Officer McHugh. If we look at page 5 of the record at the statement from Mr. Officer Chris Reagan.
Page 5 of the record?
Yes.
Okay, yep.
We have Officer, sorry, 1 minute, let me just take it to the paragraph. So if we go down halfway, it says, I took him, just under halfway, I took him by the arm to lead him away from the item he was standing on. As I did that, I looked and saw he was standing on a Ziploc bag containing smaller red bags. If we then turn to page 7 of the record, we see the statement or the evidence of Mr. Officer McHugh. Mr. Officer McHugh at page 7, if you go to paragraph 2, states, I approached the male and noticed he was shuffling his right foot and standing on a clear plastic bag, which I could see contained green and brown plant-like material.
So the description of the bag is the discrepancy that you.
Yes, the description of the bag is the first inconsistency, which we say has been overlooked when the court has come to determine the question of credibility for the purposes of the judgment in this matter. I say that because my learned friend highlights in her skeleton argument at page 2, paragraph 6, that this is not an inconsistency, but that it is a different point of view on their interaction with Mr. Buttefield. Now, nowhere in the, at least not the tangible transcript that we have, is it put that there is any dispute or any different points of view in terms of the interactions. And nowhere is it explained why the inconsistency has emerged or occurred, or what the reason for the inconsistency may be. For us, it is a very important part of this appeal because the inconsistency is with respect to what may or not the inconsistency, but the question is what may or may not have been found at Mr. Butterfield's feet. Mr. Butterfield.
Mr. Butterfield ever put it to the officers that he was not standing on any plastic bag containing controlled substances?
In Mr. Butterfield's case, it was he, albeit he not representing himself, he was certainly trying to put forward his defense in terms of not knowing. His defense is that he was stopped by the police and ran. I can indicate to this court and to my learned friend that I have actually gone through the live evidence of the questioning of Mr. Butterfield. And
But before you get to the question
Yes.
of Mr. Butterfield, I'm talking about Mr. Butterfield's cross-examination of the police witnesses. Did he ever put to the police witnesses that he was not in fact standing on any clear plastic bag containing controlled substances?
I am just going to turn to Mr. Butterfield's evidence, if I may.
That's not what I'm asking you about.
My apologies.
I'm asking about Mr. Butterfield's cross-examination of the police witnesses. And
He
whether
didn't-
he, in cross-examining those witnesses, put it to either of the officers that he was not in fact standing on any clear plastic bag or red bag or any bag for that matter containing controlled substances.
He did not put it to the officers
Okay.
in the traditional sense that he had been.
Was it raised?
It was not raised by Mr. Butterfield in terms of his cross-examination of the police officers themselves. His cross-examination focused on his running and his reasons for running.
Because I'm looking at the note of on the record of appeal, page 7, under the subheading cross-examination.
Yes.
So you see where it starts, the second sentence where it starts, or second paragraph, bag was on ground/grass.
Right.
The grass was green. So these, I presume, to be responses from the officers when he was being questioned by Mr. Butterfield.
One moment, my lady. My lady, yes, I can certainly say, just having taken a look, it does appear to be that the issue was raised, but I can say that just 1 minute, if I may.
Yes.
My lady, if I can just be of some quick assistance, the governor analyst report gives descriptions as well of the colors of the bag, and that can be found at pages 46 and 47 of the record.
Thank you very much. I think that will be helpful in due course, but at this point, I'm just interested to know how the defendant dealt with the
Yes, my lady, I can't
with the
confirm.
evidence of what was being stood on under his cross-examination. And I don't want just a blanket statement. If there's a court smart reference, because it's not clear from the note, then I would like that. But let me hear you.
My lady,
How you can clarify that.
I can obtain the court smart reference. I don't have it at this present moment, but I have, it has been explained that the questioning wasn't about the bag not being near or around the appellant's feet. The question was with respect to the color of the bag that was found. So he was putting it to them that they were wrong on their colors, but he did not put it to them that no bag was found.
Okay,
Right.
that's helpful. Thank you.
Yes.
Let me just make a note, please.
So far, we see which one.
So you said he only challenged the color of the bag itself?
The color of the contents of what was in a clear plastic bag.
Okay, thank you.
Yes. And we say that that first inconsistency with respect to the evidence of the officers as it relates to what they each saw pertaining to the appellant, that the inconsistency had never been cleared up. the inconsistency it was not put to the officers that they it was not in reexamination, I should put that it was not put to the officers that they had a different point of view or different interactions with the
What's the
appellant.
significance of that inconsistency if it was never challenged that he was never standing on a bag in the first place?
The importance of the inconsistency is that the judge is taking the officer's evidence as credible.
Yes, but it wasn't challenged. It's not as if it was put to, we're not dealing with a scenario where the defendant was saying, I was never standing on a bag, but the officer saying, yes, you were. It was unchallenged that he was standing on a clear plastic bag. Whatever the perception was of the witnesses as to what the bag looked like, it's secondary, isn't it?
My lady, I would certainly like to put a point forward that I think would definitely shed some light on the issue as to why I say that this is a difficulty in relation to the Crown's response. The Crown did not put to Mr. Buttefield that he had stood on a clear plastic bag and that plastic bag had been in his possession. That was not a matter put to Mr.
But it was a Crown's case, and the Crown's witnesses said it clearly in his presence. What's the significance of that? It's not as if the defendant did not know that the Crown, the whole point of substantiating or putting something is so that when it is followed up by evidence afterwards, it's not being, you're not catching the person off guard by not having had the opportunity to speak to it.
Right. My lady, I can only confirm or affirm that the submission is that there was no evidence adduced from Mr. Buttefield himself that he stood on a clear plastic bag. It was never put to Mr. Buttefield that he stood on a clear plastic bag.
He chose to give evidence.
Yes.
Right? In his evidence, did he deny having stood on any clear plastic bag?
He never said that he stood on a clear plastic bag. So it was not accepted and it was not denied. It was a moot point.
It wasn't challenged. So the Crown has called their witnesses, and their witnesses have said, we saw you standing on a clear plastic bag.
That's correct.
The defendant does not challenge that in any way during cross-examination of those officers. And he doesn't say anything about it when he takes the stand. And you now complain that the prosecution didn't further put it to him that he was standing on the bag?
Well, for the submission that is being made with respect to this ground, the submission is that we have a bag, but we have a discrepancy as to its contents and what the officer saw. So the reality of the court at that time is, how is this resolved? Okay, he's standing on a clear plastic bag. Is it the clear plastic bag that the Crown are saying contained either red or green, and which is it? Which is it for the purposes of the evidence and what is to be understood as being credible? Now, for the appellant's case, it wasn't denied and it wasn't accepted. It wasn't dealt with for the appellant. He didn't say. For the Crown's case, we have a situation where we have two officers that have different descriptions of the contents of a bag. So the question which the court is faced with in my submission is it a bag? And if so, what's the accuracy of the bag? And if so, what's the accuracy of the contents that the police say that they saw? In my humble submission, it is without question that the officers provided inconsistencies as to the description of the bag. It was also put to the officers that they found a lot of stuff on the field that night. Now, what stuff qualifies, it's not readily apparent, but what we are stating is that we have an aggrieved fact that's accepted that there are a lot of stuff found on the field. We have a discrepancy as to the contents of a bag that is said to be near or around the defendant's or the appellant's feet. And that is never clarified with respect to the bag. Are we talking about 2 bags, or are we talking about 1 bag with 2 different substances? And it is our submission that without that being confirmed, we have a situation where we have the appellant who is not represented, not dealing with it, the Crown not putting it to the appellant, and the officers not being addressed as to the certainty of the contents of what they saw. So as far as the judge finding that they were credible witnesses, the question is based on what? And if we are asking based on what, the question then goes to what were the facts that were presented at the trial and how were the inconsistencies addressed? And they were not, I say, addressed with the officers, and they were certainly not addressed with the appellant.
All right,
I then,
once from that point.
yes, I would like to go to the next page, which is page 3 of my skeleton submission.
Mhm.
And this is just with respect to the overall fleeing.
Yes.
At page 5 of the record, Officer Chris Reagan states that I approached him and asked if I can have a word with him. He turned and looked over his shoulder at me, but did not move his feet. I thought that was odd. I took him by the arm to lead him away from the item he was standing on. I assumed the bags may contain controlled substances and told the defendant that he was detained under the Misuse of Drugs Act. Before I could secure the defendant, he ran across one end of the pitch and out onto Woodlands Road. So again, we have a situation where we have a bag or bags, and that's not clarified. But when we go down to the next officer, Officer Hewitt says, I pointed this out to my colleagues. They spoke to the man. The man suddenly took off. At paragraph 5, I give the reasons for the evidence as to why the evidence should not be considered as credible. And it states that the evidence of Officer Reagan is that he spoke to the appellant and the appellant did not move. The evidence of Officer McHugh is inconsistent in that he states that the appellant suddenly took off as the police spoke to him and makes no mention of the appellant being led away by arm from where he stood or that the appellant had been detained. The evidence of the appellant on this is at page 11 of the record. And it is that he felt a grip on his arm and that he turned around and saw all black and ran because he did not know who it was. It is the appellant's submission that notwithstanding the appellant's evidence on this point, the police did provide inconsistent statements. The evidence of Officer McHugh corroborates the evidence of the defendant. And Officer McHugh is the second officer who says, I pointed this out to my colleague who just spoke to the man and the man suddenly took off, as opposed to Chris Reagan, who seems to have a prolonged interaction with the defendant and detained him, and then he absconds or runs from the police officers. We say that this is an important factor because the appellant's defense is that he was approached by persons in black and he was scared because of the circumstances that night. Apparently there may or may not have been a gun present at the scene of the football game that night. And he had been called to the scene as a result of concerns for safety of a family member who was actually playing on the pitch. It is not disputed that Mr. Buttefield was approached after the game. And it is not disputed that the officers were in fact wearing black that night. That's corroborated by the officers.
The officers were in visible police uniforms, as I understood the evidence. What do you mean they were in black?
Well, this is another issue that I encountered in terms of my reconciling the facts of this case. There are several different color uniforms that the police would wear, but on any given patrol, you would see them.
But tell me about, I just want to know what was the evidence? What is the evidence about what they were wearing?
The evidence?
To that evidence.
Yes, 1 minute.
Because the evidence is noted in one way, but you also get more understanding as to what the evidence was when you look at the judgment of the magistrate.
Yes. Have this point highlighted. 1 minute.
My lady, there's a line on page 7 and cross-examination of David McHugh where he says, I was dressed in full uniform. It had police on it, if that can be of any assistance. Near the bottom of page 7.
Yes, thank you.
Yes, 1 minute.
My lady, the same can be found for the other officer on page 6 in cross-examination, near the bottom. I was in full uniform and full lit body armor.
Yep, thank you.
Thank you, my lady. Outside of that, in terms of their evidence, it does not appear that they were, 1 minute. It does not appear, at least on the face of the record, that they were challenged on the color that they were wearing.
I don't
just-
know what you mean. They gave evidence for they were crown witnesses and then they were cross-examined by your client. And it seems that the subject was raised one way or the other. And the response was, as it's recorded on pages 6 and 7, I was in full uniform and full body armor, according to one officer, and he was in uniform and it had dressed in full uniform and it had police on it.
Yes, my lady. It's the position that the evidence of what the uniform was addressed in terms of that the police were wearing police uniform. The question is that, well, not the question, but what it gives rise to is the frame of mind or thought when the appellant is first approached.
No, that's not confuse this. You said that they were dressed in black. And I wanted to know where that was in the evidence. I don't see that in the evidence. And if you think that that was said, but it wasn't noted in the transcript, then the onus is on you as a matter of preparation for this appeal hearing.
Yes.
To provide me with a transcript extract of where it was stated in evidence that they were wearing black. I'm not suggesting they didn't say it. I'm just saying that that's not a note of the evidence in front of me on the record.
Yes, my lady. It evades me at this time. If I can return to it, if it does crop up while I am actually during, it's a reference, I believe, in the judgment, but I don't see it there. So I
mean, I can tell you, I read that judgment. I don't remember anything about them wearing black. I just remember the reference that they were in uniform.
Right. Yes, 1 minute. My lady, I may have to return to this. It's certainly a part of this transcript where it states that everyone has agreed that they were all in black. And I'm trying to find it, but I don't want to spend too much time on the point. My primary submission on this point is that there is an inconsistency in the first encounter with Mr. Butterfield. And
one says his arm was led away, and the other one says he gets chased. That was his.
Yes, that's the primary inconsistency in relation to that. And another reason why we say the officers should not have been considered as credible witnesses of fact. And then I move on to at the bottom of page 3, evidence of appellant with controlled drug on his person. Mm-hmm. And this is in relation.
All right, just before you go so far away from the issue of dress, on page 62, which is of the record, which is the judgment of the magistrate,
Yes.
He's dealing with what the defense had to say. He's summarizing what the defense case was on this point, and he's saying that the defendant, where did I just see it?
Middle of page
Yes,
6.
he just saw persons dressed in all black, and so he ran for his safety. I don't know if that's what you were remembering.
No, that's not what I was remembering. It's a part of this transcript which states that all persons were agreed. It's eluding me at the moment, but
I mean, it's not a long transcript. It's a pretty short record, so it just
Yes.
means that it wouldn't be difficult to find.
Yes.
But if you want to return to it, then I won't stop you. I just
Yes.
recall having seen that myself. That's all.
Yes, I think I will return to it, and if I do have an opportunity to do so, I wanted to move on to the second round of what we say is the encounter with the police and the controlled drug, which may or may not have been on the person of Mr. Butterfield. So we have Officer Chris Reagan at page 5 to 6 of the record.
Yes.
It states that me and Mr. McHugh took chase and caught the defendant. He was handcuffed and searched. A locked knife from waistband of his trousers was seized. I pried his fingers open and he dropped 2 small red Ziploc bags. Officer McHugh states, I gave chase and I saw him discard something from his pocket. I chased into the Buttefield and Valleys compound where he stumbled. I detained him. I had picked up the plastic bag when PC McHugh talked to the man. I later seized the plastic bag, which man was standing on. Now, the issue that this raises with respect to the evidence of the Crown's witnesses is it does not, and this is probably where my confusion came in, is because we have a situation where the officer, Mr. McHugh, says, I gave chase and I saw him discard something from his pocket. I chased him into Butterfield and Valley's compound where he stumbled. I detained him. I had picked up the plastic bag. There's no connection between the plastic bag being seized or being pried from Mr. Butterfield's hand by Officer McHugh and what's being found on the ground as it relates to him discarding things from his pocket.
I'm confused. You're confusing me. I understood that Mr. McHugh's evidence to be referring to his return to where the defendant was originally seen. That's when he was approached by officers, when he was sitting on the bleachers or around the bleachers, watching the game, his back was faced and never turned around. What the other police officer is referring to is after he was apprehended following the chase. So the prying of his fingers open was after he was caught. Those are 2 completely different matters.
That's not how I appreciate it, my lady, with all due
It's
respect.
how it reads.
How it reads, well, first of all, the evidence of both is that they both gave chase, which is that they both chased after Mr. Butterfield.
Right. One went to go and get the plastic bag that he had originally been standing on, and the other was prying his fingers open after he was caught, getting other drugs from his grasp, which dropped on the ground. That was the Crown's case.
My lady, if I can just take it piece by piece when it comes to Officer McHugh, because I think we have a little impasse regarding the evidence of Officer Reagan and Officer McHugh. Mr. McHugh and Mr. Reagan both agree that they gave chase. It says by Officer McHugh, I saw him discard something from his pocket. I chased him into the Butterfield and Valley's compound where he stumbled. I detained him. I had picked up the plastic bag when Mr. McHugh talked to the man. I later seized the plastic bag which man was standing on.
Yes. What's wrong with that?
Okay, so we have a situation where it says I had picked up the plastic bag when Mr. McHugh talked to the man. Now, it doesn't say that he picked up the plastic bag before he chased Mr. Butterfield.
No, it
And we have
doesn't.
Mr. Reagan
He
saying,
later sees a plastic bag that the man was standing on.
and for me, this is the issue that I'm having. We have Officer Reagan and Officer McHugh both chasing after Mr. Butterfield. Mr. McHugh does not corroborate that anything was pried from Mr. Butterfield's hands, or that he witnessed anything being pried from Mr. Butterfield's hands. Mr. McHugh goes on.
Was it put to Officer Reagan that nothing was pried from his fingers? Did your client put it to him during cross-examination that he was not telling the truth, or he was wrong one way or the other about?
Yes, my lady. Mr. Butterfield did put it to Mr. Butterfield did put it to Mr.
It's
Reagan.
not noted in the evidence.
Yes.
Page 6 is a cross-examination. It's a very short paragraph.
Yes. My lady, I would be happy to supply the court smart record, but there
That
is
should have been done by now.
no.
So the case management part of this, you know how this goes, Ms. Tucker.
Yes, I do.
I don't like disruptions to the substantive hearing.
Yes, I
Case
appreciate that.
management hearings, if you have an issue with how the evidence is noted, you go and
Yes.
get a transcript of that evidence, you agree it with the Crown, you get ready for the hearing.
Yes.
You don't disrupt the hearing now with that amounts to a lack of preparation. If you say that the record is not fairly depicting what the evidence was, then that's part of your preparation.
Yes, my lady, and I do appreciate that. It's not so much a lack of the preparation. It's just a matter of trying to have my papers in front of me and
No, fair enough. But what I'm saying
yes.
is I'm relying on the notes of the evidence.
Yes.
Right? So when I ask you if Officer Reagan was cross-examined by your client as to on the evidence of his fingers having been pried open, that question is somewhat rhetorical on my part, because I'm looking at the cross-examination notes on page 6 at the bottom, and I
Yes.
see reference to it. If you're
Yes.
saying that was incorrect, then it would have been incumbent on you to have gone and liaise with the prosecutor and said, listen, I don't know why this is not being noted properly, but this
Yes.
is, this is in fact what was said at trial.
Yes, and my lady, I do take that on board. I am going to move on from the point because, one, I don't have the record.
But we want to get to the truth of it. Hold on.
Yes.
Hold on. I still want to know what the position is in reality. So if you need, I don't intend to delay in putting out judgments.
Yes.
So I'm going to give you a very narrow time frame to get a transcript of what you say was in fact put. You have to liaise with the prosecutor, agree it, and I will give you to the close of business tomorrow to do that.
Yes.
You wouldn't have much longer than that because,
Yeah.
we have to move on. We're long past that stage.
Yes, yes, my lady, and I would appreciate that just for the sake of the transcript references that I am trying to adduce for the purpose of making this particular point.
But I don't want to be misunderstood. What I'm expecting for you, I don't want any court smart references.
Yeah.
I want a typed, agreed transcript emailed to me that
Yes.
sets out what the defendant asked the Crown witnesses in cross-examination on the points that you say were put to those Crown witnesses.
Yes, my lady, I'm very clear on what the court is
good.
allowing.
Okay,
Yes.
good. And then you will, and before you send that in to me, you have to agree it with the prosecutor so that what's coming to me is an agreed transcript extract.
Yes, and that's certainly what it will be limited to and nothing
Okay.
further.
All right, okay.
Yeah, so my lady, for just moving on and for the sake of completeness, at paragraph 7 of my submission, I do state the worship's judgment that he says, I am satisfied that that ease of the prosecution's witnesses, it should say, witnesses were credible and truthful witnesses. We submit that because of certain inconsistencies, which will be certainly clarified with respect to transcript, that he could not have found that they were consistent, and therefore he could not find that they were as credible as he deems them to be. I am, my lady, going to be moving on to appeal ground 2. And I'm going to state that the appeal ground 2 is not the strongest appeal ground, my lady. And I would say it's the weaker of the 3 grounds that I have presented. The purposes of appeal ground 2, well, at least it sets out that the worship magistrate erred in law by failing to admit, consider, or otherwise direct himself on the firsthand hearsay evidence of defense witness Jericho Gardner. Now, I definitely am of the view that, and I have been supplied with the dates of court, and I can certainly affirm that there seems to be many instances where Mr. Gardner could have attended and may not have done so. In one instance, I do see that Mr. Gardner wrote to the court to explain his circumstances. And it's my position that at the very least, given that the appellant was unrepresented, that the court or the magistrate ought to have had at least some mention in the judgment of Mr. Gardner and his inability.
I'm very confused. Who is Mr. Gardner, a defense witness that you wanted to, that they defended, what your client wanted to call?
Yes, Mr. Gardner is a witness for the defendant, the appellant.
Did he actually give evidence?
He did not give evidence. He
wasn't a witness.
He wasn't a witness, but I make mention of it because it's part of my overall submission that the court did not provide as fulsome a judgment as it could have been. And one of the things that could have been referred to was the evidence submitted in a letter to the court.
It's not evidence.
Well, I appreciate that, my lady. And with that being said, it is, as I stated, the weaker of the points and one that I would like to abandon at this particular juncture.
All right, thank you.
Okay, so that leaves us with the last ground of appeal, which is appeal ground 3. And it states that the worshipful magistrate failed to direct himself on any points in favor of the appellant or assist with any point of law arising from the evidence produced by the Crown for the purposes of the unrepresented defendant. And what I state by that is that there appears to be 2 major issues at play here. One, that the defendant has denied knowledge of drugs being in his possession. And 2, that the court directs themselves as to the defendant telling lies, and that the court did not properly direct itself as to the potential for lies to be innocent lies, or why it feels that the appellant has lied. And in relation to the first point, my lady, I do want to state that I do not agree with my learned friend that knowledge was not an issue in this particular case. And it certainly is apparent if we turn to the appellant's evidence, which is at page 12.
Page 12
of the record.
All right.
If we go halfway down, it says, yes, police found a knife and drugs on me. And then it says, something was on me. I don't know what was on me. They took the phone out of my pocket. The phone in evidence was not my phone. I don't know type of drugs I had on me in the jacket. So in this particular portion of the case, we have two distinct challenges, or at least two distinct responses to challenges, that Mr. Butterfield did not know what was on him and that he did not know the type of drug that he had on him. I have with some particularity as it relates to at least the cross-examination, reviewed the court-smart transcripts, and I can say that it was put to Mr. Butterfield that well, I'm not going to give the court smart reference, but he does say, I didn't know that it was shatter. I didn't know it was cannabis. And it's put to him on several occasions that he had drugs on his person, he had drugs on him, but he denies that he knew of that they were drugs, or that he knew that they were cannabis, or that they were shatter. One of the issues that presented itself during the cross-examination is that there is a lack of centralization to the primary issue. So if we have drugs at his feet and we have drugs in a jacket, we have a situation where these drugs have to be identified, and the appellant either has to be shown that he controlled it as in possession and that he had knowledge of it. The appellant at all times stated that he did not know. He says, no, he did not have it on him. It was put to him that you ran because you knew you had drugs on you. He says, no, I did not know. And it says, sorry, the transcript says, they say it was drugs, but yes, they found drugs. So then he says, they say it was drugs. It's a further corroboration to his lack of knowledge that he had drugs on him. It was put to him at 108 of the cross-examination. You had drugs in your hands, your jacket, your trouser
Sorry,
pants.
are you reading from something that is in front of me?
No, I'm giving references, and I would like just to indicate that I am also going to supply the court with these particular court-smart references that I'm making, because with respect to the cross-examination, these are points which I believe were pertinent to the knowledge portion of this particular exercise.
Okay, let me just suppose for a moment that I accept that the evidence discloses a clear defense that was raised by your client as to lack of knowledge. Where do we go from there?
Well, where we go from there, my submission, my lady, is that the learned magistrate failed to deal with the defense of knowledge in any part of the judgment which was rendered. And we say that that poses an issue or a challenge because the magistrate ought to—
has he not dealt with it just by accepting the Crown's evidence that, number one, it was pried from his fingers? So from that, you can deduce that he knew full well what he had, because he was gripping onto this object and he had to pry it from his fingers. And he also accepted the evidence that he was standing on the other plastic bag, that and by standing on it, he was trying to conceal it.
Well, my lady, it would have to—
considered, I mean, maybe perhaps not to your approval, but he's considered the issue of knowledge by accepting the Crown's case on those facts. Has he not?
He's accepted the Crown's case on its facts, but the issue that the court ought to be concerned with is, why isn't the defense case being as clearly put as it possibly can be? I make reference to this because I have presented this court with an authority of Art Simons. And in this authority, Justice Kawley explicitly points out that and I can go to that authority at page 9.
I have it open, go on.
He states at paragraph 20, this is not because of a mere mistake in terminology. Rather, it is because it is impossible to ascertain from the judgment on what basis the learned magistrate rejected the central tenets of the defendant's case. What is meant by that, or at least what we submit is meant by that, is that there is no unequivocal rejection based on knowledge. Your worship brother, Magistrate Takumbo, did not give rise to or did not expressly set out for the record the facts that related to the defendant's case, and that he did not know that he had drugs in his possession. He does not distinguish that the defense case is that he did not know it was cannabis. He did not know it was the drug called shatter, and the reasons why he may not have known. He's centrally focused on the issue of the Crown's case, my lady. And the Crown's case was opposed to and was not accepted in terms of knowledge. And the defense case is that there are certain elements that, at least at the root of this, should be addressed. And that is the elements of the offense itself with respect to the act and the mens rea of the mental element. It is not the submission of Crown that the court ought to have delved into every facet of the Crown's case. But what the court has not done is it has not even shed light on the fact that the defendant says he did not know that the drugs were in his possession. And you cannot, from this judgment, glean that the court properly addressed its mind to the defense's case in that regard. We have a situation here in which we have an unrepresented appellant, and all should be done to ensure that justice is done fairly and that it's seen to be done. If we are to look at the appellant as having had a fair trial in this matter and glean it directly from the judgment itself, it would appear that he did not, or he was not afforded any real deliberation or conclusion with respect to him having known that the drugs were either by his feet or that the drugs in his pocket, that he had knowledge of them, although he does accept that they were found on him, at least those drugs. Outside of the issue on knowledge, I then relate to the issue on lies, because the issue on lies, we say, goes to how the judge considered the appellant's case. And we certainly don't have a direction from the face of the record that the judge considered why he may have concluded that the defendant was lying, or whether or not those lies may have been considered to be innocent lies or some other type of lie. Now, or reasons for the lie, I should say. And I also want to go to Art Simons at page 9, where it states, Ms. Simons, and it's a mere coincidence of the Simons, in response to the ground of appeal as articulated in the appellant's skeleton arguments, was almost entirely sound. The learned magistrate did not err in law in his approach to the lies issue. His judgment does explain that what he considered to be a lie on a material issue, why he bought in the toiletries and who he bought them in for. The issue as it relates to this defendant is that we have a material issue which is on knowledge. And the judge in his decision does not draw a reference or make any distinction as to why he finds that the defendant is lying and why he says that that lie impacted his decision as it relates to his finding that he knew or ought to have known that the drugs were in his person. And the judgment does not even say that the appellant knew or ought to have known that the drugs were in his possession. What I have with relation to this, at paragraph 12, I state that the first point of law which the Russian magistrate does not consider in his judgment is the possession when knowledge is disputed, as it relates to the items found in the jacket the appellant wore. The second point of knowledge of possession is as it relates to the drugs found near the appellant's feet. At paragraph 13, it states, as it relates to the first point, Lord Scarman remarked in Boyson, and that's at page 6 of the judgment, that possession is a deceptively simple concept it denotes a physical control or custody of a thing, plus knowledge that you have it in your custody or control. You may possess a thing without knowing or comprehending its nature, but you do not possess it until you know you have it. Now, the issue that raises is that in dismissing in not addressing for the purposes of the judgment, we have no real privy to what the magistrate considered and what his ultimate conclusion was. And in back of that, we have a backdrop of the magistrate considering the defendant to be a liar, but not how that relates to his overall finding that the defendant either possessed it and or had knowledge of these items that could have been.
Ms. Tucker, do you accept that if the magistrate believed the Crown witnesses, if he found their evidence to be true on the facts asserted, that it would be most unusual for him to accept those facts and then to still question the issue of knowledge? On the facts of the Crown's case, the object containing the controlled substances was pried from your client's fingers.
Yes.
We're not dealing with a case where a concealed package was embedded somewhere in a suitcase, and now the question of knowledge has to be further explored as a separate issue.
Mm-hmm.
On the facts of this case, the defendant, if the court accepts the facts as they were sworn on the Crown's case, the defendant was trying his hardest from the sounds of it, or you can take it that he at least was clenching his hands in some way, that his hands had to be pried open. And in respect of the other controlled substances, he was concealing them by standing on them. How does knowledge arise as an issue if those facts are accepted?
Well, it arises as an issue, my lady, because when we are talking about possession of a controlled substance, we have the assertion that Mr. Buttefield had possessed these items, that these items were on his person. It was never put to Mr. Buttefield that he had knowledge of the items that he had in his possession. And one of the key issues that gives rise to is that if Mr. Buttefield was not challenged on the primary facet of his defense, which is knowledge, and he's not, or at least the magistrate doesn't appear to draw his mind to him knowing that he had controlled substances or drugs in his possession, we are in a situation where we have to question what the learned magistrate did consider as it relates to the defense's case, not so much the Crown, who are arguing that he had it in his possession.
There's a cross-examination of the defendant.
Cross-examination of the defendant is found at page 11.
So where the defendant says something was on me, I don't know what was on me. That was an answer to a question from the prosecutor.
And that question I would submit is not based around knowledge. It was based around possession.
I don't know what was on me. I don't know what was on me is what it reads.
Yes, but
not related to knowledge.
What my position is, it was not put to the defendant that he knew that he had these controlled substances.
His response then reads, I don't know type of drugs I had on me.
It was put to the defendant that he had drugs and shatter in his possession. It did not say that he knew he had it in his possession.
Miss, let me see if that's what the Miss Simons Fox, what's your position as to what was put?
Your
particular point.
worship, I'm sorry, my lady, I'm listening to my learned friend, and I heard her say earlier when she was reading the transcript that I kept putting in my cross-examination that you ran from the police because you knew you had drugs on you. That was in her earlier submission. I don't have a copy of that transcript, but I do recall putting that to him. You knew that there was drugs on you. So I disagree that I did not put that to him.
Well, that's got to be part of the transcript that's put before me for tomorrow, please.
Yes.
Because anything that, I mean, it's the position, it's standard for the appeals. Anything that's disputed as to, or anything that's incomplete on the notes of the evidence, counsel have to get together and fill that in with an agreed transcript. And I think that has to be part of the transcript.
Yes, my lady.
All right.
Yes, my lady. And just in relation to my conclusions on this particular point on the knowledge, I say it's imperative that the magistrate draw his mind to the knowledge of the defense, because the defense has to be considered properly. The defense has to be shown to have been considered properly, and it ought to have been properly fleshed out that the court found that the defendant knew. And for us, we say that because we have a lack of information as to the lie, or that it was a big lie and the reasons as to the lie, and because we have a lack of understanding as to what the court considered when it considered that the respondent had knowledge, we say that the judgment ultimately cannot be considered as safe. And this is especially in light of the fact that the defendant was a person of good character, but for this conviction. And we say that that does hinge on the direction which the court ought to have given itself and ought to have reflected in the judgment with respect to lies and the reasons why he considered the defendant to be a big liar. And in my submission, my lady, without the clarity on that and it being properly identified for the sake of the record, I do not have any further submission, but I do submit that the court should find that the judgment is not safe, and it should be read in tandem with the fact that there are inconsistencies with the Crown's witnesses that were not addressed, and that there were reasons why the defendant is found to be a big liar that is not addressed. And there is no information diluted from the judgment that shows that the court ever considered the defense's case with respect to him having knowledge of drugs, one, under or nearby his feet, which was disputed, and drugs on his person, whether they be in the jacket or in his hand. And I'm still not sure if they were both in the jacket and in his hand.
You're not sure if they were in the jacket and in his hand? What do you mean?
No, I'm saying I'm not certain if it's the defense's, or if it's the Crown's, if it was the Crown's case at trial, that there were drugs in his hand.
On both
Both
the
places.
hand and the jacket
Yes,
on the Crown's case.
on the Crown's case.
Okay, well, I thought it was pretty clear from the notes that I read, but I'll see what Ms. Simon Fox has to say. All right, thank you very much, Ms. Tucker.
Thank you.
Yes, my lady. Is there anything in particular you'd like me to focus on?
It's really about what was put to the witnesses, because I don't think that you need to deal with the examples of discrepancies that Ms. Tucker took me through, but I am quite keen to know what was put to the police witnesses during cross-examination by the defendant, no appellant. And
Yes,
It seems that wouldn't be resolved until I have a transcript of whatever's disputed.
yes, my lady. I would agree with you on that point. I do recall his cross-examination not being long at all for any of the witnesses, but in order for you to get a full understanding, I do agree that we would have to provide you with an agreed transcript on that particular point so that you can have a full view of what was said.
The other thing is that you can address me on is the non-direction that Ms. Tucker complains about on the issue of lies by the magistrate.
Yes, my lady, I would have to disagree humbly with my learned friend.
Mhm.
I believe that the magistrate's judgment is very detailed. He draws his mind to, as we can see, verbatim what was said by the defendant before he
Yes.
considers his analysis. In his analysis, as you have mentioned before, he found the Crown's witnesses to be very credible. And because he found the Crown's witnesses to be credible, he found that what the defendant, or now appellate, was saying was simply a concocted story. In order for the magistrate to find the Crown's witnesses credible, it means that he found what he would also then have to find that the defendant was incredible.
Mhm.
So I don't think there is much more to say on that point. And I noticed earlier, my lady, the point about the colors of the plastic bags, and I drew your attention to the government analyst certificates that make
Yes.
mention of both red and clear Ziploc bags, and they were both handed up as exhibits for the magistrate to have a look at to see what the bags look like.
Sorry, what's the significance of that?
I highlighted that point earlier about the
Mhm.
colors of the bags, so I didn't know if you wanted more clarity, so I'm just bringing that back to your attention. My learned friend in her submissions were talking about
Yeah,
those
that's when she's talking about the
inconsistencies.
inconsistencies.
Yes.
Yeah, okay. No, I
Yeah.
don't think I need to hear you on that. Non-directional one. Right, and let's see, also, again, another matter for the transcript, if there was any reference to the police officers wearing black, in the evidence. We've seen in the evidence that the appellant said that he saw all black, but I didn't see anything from the notes of the evidence that would make me think that the police officers were wearing the color black
Yes.
or dressed in black. And if that's conceded, then fine. If it isn't, I mean, how far it takes us is another matter, but I did not take from the evidence that the color that the police officers were wearing was stated.
Yes, my lady. We can definitely clarify that in an agreed transcript. I do recall the officer saying that they were different types of uniforms, but they couldn't recall which uniform they would be wearing on that day. They just know that it would be marked police.
Okay. Well, I mean, if that is an agreed position between you and Ms. Tucker, then that doesn't have to be transcribed. I'm happy to accept that.
Yes,
as
my lady.
agreed, but I think you'll have to be clear with Ms. Tucker that that's the position.
Yes, Ms. Tucker.
Yes, I'm grateful. Thank you.
What does that mean? That you
It's
think
not
that's transcribed? I mean, if the police officers don't recall, if they said they don't recall what they were wearing, that's another matter. But I did not see it on the Crown's case noted that they said they were wearing black, or that it was agreed in the evidence that they were wearing black. That's a much stronger statement.
Yes, what I'm saying is that because there is a reference that I did mention that I saw to it, and I'm not certain if it's something I noted from the transcript or if it's not apparently visible in the transcript that we had from the magistrate's notes. So I don't want to agree as position on if it appears that in the transcript there is the challenge on the black and what was accepted. So I certainly don't want at this stage to agree that that the officers did not accept the color of clothing they were wearing.
All right. Well, the way I see it, Miss Simon Spox, is quite honestly, I would not have called upon you to address me on anything other than what was put
Yes,
in cross-examination. So unless you feel that you need to address anything, I don't need to, I don't feel I need to hear you on anything other than the subject of what was put during cross-examination. You've properly addressed me on what Ms. Tucker complains of as a non-directional lies. And so I think that that's fully noted as to what the Crown has to say on that.
yes, my lady. I don't have any other points I wish to highlight.
Okay, all right. Well, that being the case, let me formally direct the filing of an agreed transcript on any contentious parts of the evidence or anything that is material to either side, and that has to be filed by close of business tomorrow, please. Sent by email, because I'm expecting it to be 1 or 2 pages in length, not much more than that. But I will also comment that when you are sending in, and I don't know if this was done on both sides, but Ms. Tucker, I do believe that that was an issue when you filed your submissions this afternoon, or authorities. I know that there is a very enthusiastic approach by counsel for the court to operate electronically, but the court associates are, I think, inundated with the task of having to print authorities and submissions, etc. When they come in like that, you really should be filing a skeleton argument and authorities bundle. It's not the role of the court staff to come in and to give me what is effectively becomes a loose leaf compilation of papers that I now have to sort through. So,
And I appreciate.
yes, if you're directed to file skeleton arguments and authorities, please send it in a hard copy bundle if it's going to be anything more than a 2-page, 3-page attachment.
Yes,
Okay.
I'm grateful. Thank you, my lady.
So with that, I will, it's my intention to give a judgment after I receive whatever's the agreed transcript. I will allow for any written note. It needs to be concise and only on the point as to what the transcript relates to. You can accompany that with a note. I'm saying a note, not a skeleton argument. Please don't give me a renewed, fresh skeleton argument. A note. It is not my intention to have another hearing. It is not my intention to hear from counsel any further. Okay.
Thank you, my lady.
I'm grateful. Thank you.
Okay. Thank you very much. This hearing is adjourned.